So what I'm gonna do is explain how Douglas Christopher Hanson cheated my post-conviction relief, and he had my attorney Coben Patterson tied up, right? And he didn't allow my side to put on any evidence, which I think is just wrong, absolutely wrong, if you ask me. So, if you guys paying attention and you want to know about law, there's a lot that I'm gonna be teaching as far as showing the proof and the evidence. As far as I'm concerned, until they hold Douglas Hanson accountable for his unethical misconduct and his illegal conviction on me, I'm just gonna keep on doing what I do best. And so now you'll see that I got my core audio transcripts up there, and I got my paperwork. Knowles Griffithson actually was my attorney, but he took Coben Patterson under his wing, right? And he assigned the case from himself to an attorney in his office by the name of Coben Patterson. Now, the reason why I'm bringing up this paperwork before I get into that actual paperwork, because I'm going to switch screens and all that, right? The reason why I'm showing you this is because these court audio transcripts, which this judge is going to read off, we're going to get into the paperwork itself. In close is a motion to disqualify this same judge, and the reason why I'm disqualifying this judge is due to the information that Douglas Hanson put in behind the court's back, and this is just going and showing proof that what this man did to me was just flat out wrong. So he's going to read off this case number, and I'm going to pause it, and then we're going to get into the motion to disqualify him. And the reason why I'm disqualifying him is because he is prejudiced on my case. He's not going to rule correctly. He's not going to look at the information. He's not going to do... You can open that to see what's in it. Do it at the table, though. He's not going to rule fairly, and I told my public defender Coben Patterson about this once I figured out what was going on, right? But they did not want to hear me out. Everything that I was saying was incorrect, wrong. I was schizo. I was losing my mind. I was incompetent. And you know what's so funny? I'm gonna put on everything. I'm gonna do what they did not do. When a person lie and somebody else can show that that person is lying, and it hurts that lie hurts that person's life and take away pursuit of happiness and all that. Come on. I don't know, one, like I keep on saying, and I don't mean to keep on throwing you so-called pastors under the bus, but I can assure you that you guys need to start learning about civil rights. Because if your pastor don't know how to protect your civil rights, then nothing... You're not going nowhere. I learned that. Take it from me. I cried out to churches. I was going to church on house arrest. I was told I couldn't go worship and practice my religion because the PO was willing to lie. I was under appeal when they said I wasn't. They told the POs told me I wasn't under appeal, but yet I was receiving so much appeal paperwork. Now you see my case number right here, that 18CV. My original appeal number is my original case number is 14C42686. But since I moved the courts for an appeal, I went under what's called civil court proceedings. You can't look this case up in the Oregon e-court system publicly, because this is considered me raising claims of civil violation, constitutional violations. And what I'm saying about Douglas Hanson saying, Your Honor, I don't do PCR. Of course, the defendant can have... Actually, I gotta go I don't want to put no words into Douglas Hanson's mouth. So I should have did this before I. Hold on, guys. I love you too. So this is the reason why I'm appealing my case.
State versus Matthew Mayfield Johnson Jr. 14C 42686. Defense counsel Gail Ryder is present with the defendant who is out of custody. Doug Hanson for the state. Your Honor, this is the time and date we had set up for a change of plea in this matter. It is my expectation the defendant will be entering no contest pleas to counts 1 and 2 of the indictment. And we have a stipulated agreement.
Which is a lie.
UCJ offer worksheets have been provided to counsel and the court, and I can go over that at the appropriate time. I will say that this has taken extensive negotiations. I think this is a good resolution to this matter. I think all parties are ready to proceed.
No, we're not.
Thank you, Your Honor. If I may approach, I have for the court a petition to enter pleas of no contest.
I was screwed over. I want to tell people that.
Executed by Mr. Johnson after review of counsel this morning together with a notice of suspension.
She didn't explain nothing until the date
Go ahead and
of.
stand up, please.
Come on, Susan Tripp. You're going to have to be
Mr. Johnson,
disqualified as a judge when I'm done running this.
Mr. Johnson, I have before me a plea petition. Did you go through
Hey,
that? with your-
Hey,
Yes, ma'am.
hey,
Did you understand the things your lawyer
don't
has
lose
told you?
those.
Yes, ma'am.
Do you understand
the
that if you
toys
give up your right to
that
a
was in
trial,
there.
all that will be left is for me to impose this sentence,
You can
which
hear it in
is,
my
in
voice.
fact,
I didn't want
a
to take
downward
this
departure.
plea.
Yes, ma'am.
I did not
Has
want it.
anyone made threats or promises to get you to do that today?
No.
If she would have said yesterday, I would have said yes.
To the charge of delivery of oxycodone within 1,000 feet
Keep
of a
it
school
all together.
as an 8B with a presumptive
That's why I
35
did not
to
want
40
you to
months,
open it.
knowing that there's a downward departure. How do you plead?
No contest.
I'm going to be
Count 2, promoting
paying
prostitution
attention to my
as an
kids too
8B,
while I'm doing this.
presumptive
So
35 to 40 months with a downward departure pursuant to agreement. How do you plead?
No contest.
Okay. Go ahead and have a seat, and what the state needs to do is fill in some facts for you.
give me that.
Thank you, Your Honor. If this had gone to trial, the state would produce evidence that on or about May 16th of 2014, at a
Give it
location
here.
of Shiloh Inn of 3304 Market Street, Northeast, room number 419.
If you lose those
which is
pieces
within
and you
Marion
don't do your
County,
homework, I'm gonna
the
be mad.
defendant was in a hotel room with his
Whatever
wife,
was in
Jessica
that
Johnson.
envelope,
There
it's
would have
pieces
been
on the
an
floor
agreement between Ms.
already
Johnson and an undercover officer to engage in sex for money.
for
The officers had
your
arrested her.
homework.
The defendant was in a closet.
Get
They
it.
came out,
Put
and,
all that stuff
he
back in
was
the
there.
envelope.
The officers had talked with him. It was discovered through information provided by Ms. Johnson.
No, it's
and
for
the
his
defendant,
homework.
After Miranda writes that he was there assisting her in the promotion of the
This is
prostitution.
a
She
lie.
indicated to officers that she shared the money and the proceeds of the prostitution with her husband, which is the defendant. Further inquiry on the cell phone of the defendant was found text messages that were consistent with that. Also, text
He's
messages
lying.
in
Listen
regards
to
the
him in his
oxycodone,
voice.
where he was trying to sell 50
Just-
pills of the oxy.
He gotta lie to Susan Tripp, and Susan Tripp is lying, accepting the lie because she already know what's going on. A real judge would have said, "Where's this victim? Where's the wife? Where's?"
We still don't know who Nick is.
You don't know who Nick is, but you charging me.
Constructive
It's a
delivery.
constructive delivery
In that
with
location,
who?
Based on the fact that he still had the cash, the oxy pills were found in the room in his wife's purse.
In my wife's purse, but I'm charged with a
Of course, can't show
constructive when I don't
That's
have
what he was
possession.
able to do.
Give me a
The
break.
totality of circumstances would show that he was actually delivering oxycodone on a constructive delivery. on
Quit
or about
lying,
that time.
Douglas
Text
Hanson.
messages the day before, as
The
well.
man is a bad prosecutor. I
That
repeat.
would be sufficient for those pleas. In regards to being 1,000 feet of the school, it was within 1,000 feet of Hoover Elementary School within this county.
That's a
All
lie.
right.
That's a lie.
Ms. Ryder,
They,
I understand that there's been an agreement.
Listen to
between
my-
the parties.
listen to my
Is there anything
defense,
else?
guys. This is the reason why I didn't have a
We
choice.
stipulate that if the state were to.
If Douglas Hanson put on,
without any evidence from the defense.
What?
Those are the facts that the state would be.
that's a
able to
lie,
prove.
Gail Ryder.
No, Your Honor, this is as Mr.
I can hear it in your
said,
laugh.
This resolution is the result of a number of different negotiated possibilities.
Oh no! Don't.
And we are asking the court.
No, we not.
to
You are.
impose the sentence
You
as
asked the
stipulated
court.
by the parties.
You did. Y'all took away my whole
Mr.
voice.
Johnson,
Watch, I'm gonna explain it in my
I've
next
heard a lot about this case.
I bet.
Stipulations.
Yeah, after you
Like
call
tell me.
officers to illegally testify.
I don't even know what to say about
Right.
this. I've been fighting it for
I've been
14 months.
what happened to due
I
process,
sit here
fast
and
and
tell you that,
speedy trial.
It's not true, but I'm at a position
Where I don't have
feel
help.
Like I don't have help.
I
so
didn't.
I have to do what's right for my kids.
right.
You know, if I didn't have kids,
Man, I would have went to trial.
But being that I'm a father and I
They
love my
leveraged
kids
me
and
with my wife and kids.
I would like to have an opportunity to show that I'm not the person that they made me out to be, the officers. I understand Mr. Henson's job as a
And I was
district
giving this
attorney
dude
and,
credit.
also my lawyer, Gail Ryder's job as my
Private counsel.
But at the same time,
I
I
was
was never
given a
an
chance.
actual chance.
I was never given a
show
chance.
evidence.
Showing
and
evidence.
I further would like to appeal it.
Using my rights. That's what I told them.
That's all I have to say.
That's all I have to say is let me appeal it. Now listen to this. Listen to how she playing around, smacking her lips, doing this on court audio transcript. And they didn't think that I would be smart enough to get these court audio transcripts to play them back. Everything that I've been doing has been truthful. Douglas Hanson cannot arrest me for violating the fake-ass stipulated protective order, and this is the reason what's leading into disqualifying this judge right here is because I know Douglas Hanson dirt, and now Susan Tripp is trying to read through this to try to explain to me that I'm giving up all my rights, and I'm going to check her for that. Trust me, I'm going to check her for that.
Okay.
If there's limited rights, what are
You
those
signed
rights?
this document,
Yeah, I know.
and in this
Forcefully,
document,
coercively.
you were stipulating to a plea.
No,
Okay.
no.
What I hear you saying,
What I hear you say, you ain't hear me say shit.
you want this deal,
Nope.
and that's called an alpha.
I thought it was called a no
Basically,
contest.
You want the deal.
No.
You're pleading no contest.
No.
Because you want the
No,
deal.
no,
The state's willing to come off.
no,
with a
no
presumptive
right person
prison
in a
sentence.
mind will go to trial
So
with no
that-
evidence.
You can get a chance to show that you're a different man.
Oh yeah, I
Yeah.
am. I'm gonna
These
show
charges will
you
show.
beyond reasonable doubt that y'all fucking crossed the line.
And you're entering this plea
It's only one way out for me,
knowing what the state's evidence would be.
and I don't
And
have
you're
none.
saying, I'm entering a no contest plea because if I presented
This is
no
how they
contest,
setting people up, man.
the state would be able to make
Hell no, he can't. Hell no.
and
I'm gonna
What-
show
what I
you
hear
why
you
he
say
can't make his
is
case.
that you're entering that plea in part because you believe that it's in your best interest
I don't have a choice,
to
Trip.
enter a plea.
I don't have a
Is
choice.
that right?
Yes, ma'am.
I don't have a choice.
And you're pleading no contest.
My old
in order
attorney
to
didn't
get
want to put on
the
no
deal.
evidence for me. She didn't even want to put on a piece of
No.
paper for me.
At the bottom of this
Yeah.
thing that you signed, this plea petition,
A
it
plea
says,
petition.
I understand that by entering my plea, I am giving up all right of appeal.
That's a lie.
Okay.
Watch what I tell. Watch what I do.
So unless the sentence imposed exceeds the maximum allowed by law,
Which it doesn't. You see how she's saying that?
basically you're giving up your right to
Nah. It wasn't gonna be that kind of party
it.
trick.
So you're taking that deal
No.
and you're agreeing with the state. That's it.
Nope.
I'm gonna show
No, that's
I'm a
not
different
it.
man.
That's not it.
I'm going to look after my children.
I'm gonna do that.
I'm gonna take this downward departure.
I had no choice.
So I don't go to prison
The DA, the public defender, and the
Potentially
judge was
could
against me.
if I went to trial. So I'm gonna plead no contest.
Nah.
And
nah.
they're going to come out of the presumptive sentence.
What? They can't do
And
that.
ask the court,
Prosecutor had too much
why
discretion.
stipulation to come out of a presumptive prison sentence
Yeah, I
that
bet.
you might face if you went to trial. You might be found not guilty.
I was not guilty. Not
But you
guilty.
might
Not
end up
guilty.
facing a presumptive prison
Not
sentence.
guilty. Take me back
So-
to court.
Here's the question.
Take me back. This case is so tainted that
You're
they can't take
signing a
me back to
document
court.
as part of your plea that
No.
you're giving up
No,
all rights of appeal.
that's a fucking
You're
lie.
taking the deal.
That's a lie.
That's that.
Nope.
And that's not what Miss Ryder
Ryder.
just explained
To me in the hallway.
I literally asked her if I could appeal within 30 days.
And she told me
yes.
what?
And if I may.
Well, explain yourself.
I think that the statement in the plea petition
It's a little
is a
what?
bit too literal.
Literal
Under
for me.
current law, a person
Under
is entitled
current
to
law
file a claim
of
for
appeal
or a
if-
notice of appeal
If
they can state a colorable
colorable,
claim.
and my
for the
colorable
appeal.
claim is
Now,
no
I know
no
under-
victim.
When you enter a plea, whether it's guilty or no contest,
No victim.
those rights can be very limited.
What? Well,
But
where
if
is
the
it?
public defender's office, after consultation with Mr. Johnson,
Which they
can
never gave
find
me
a
consultation.
colorable claim for appeal.
They
then
just
the notice
filed
of
the appeal without
could be
even
filed,
talking to me.
notwithstanding what the plea petition says. That's my understanding of current law. So while he has limited appeal rights, he still does
Yes.
have some appeal rights. I think that the
I
plea petition
still have
is a
what?
little
Some
overbroad
appeal-
in its language.
Then what are those appeal rights?
Because I think the plea petition is designed to make sure that people understand things are going to be very limited.
Nope, I didn't understand that one. I did not
That's my
understand.
reading of the plea
That's
petition.
your reading. That wasn't my reading. That's your reading of the plea.
Your Honor, I know that there are, of course, post-conviction rights that
Uh-huh.
the defendant has
Yeah.
that are separate from appeal rights. That's something that potentially is still there. I don't know. I don't do PCR.
Oh, then why you leave the
But,
Marion County
if
DA's
there are
office,
claims
cheater?
that he has against his prior counsel.
Yeah,
He may be able to file appeals or
Yeah.
that. I don't know.
yeah.
But here I do understand that there's very limited rights in regards to appealing this conviction.
Oh man, he's so caught up. He's so caught up. You know what I'm saying? Now I'm not gonna play with Douglas Hanson no more. He wanna play games. He wanna cheat the system. He wanna disqualify people, and he wanna act like, you know what I'm saying, he's the one. Nah. Now let's get into disqualifying this judge. Please find a motion disqualifying Daniel Penn and purpose order. I neglected to include these documents with my previous mail. Please let me know if you have any questions. See, there's motions. There's motion. Douglas Hanson don't want the public to see this. But see, that's why it's under a civil matter. And I don't care. They've been cheating me so much. It's time for me to come forward like any other person that's crying out for help. And I'm crying out for help. I'm asking the public one thing here is, how can one man get away with cheating so much? Motion to disqualify this judge under the grounds that he claimed that he signed a stipulated protective order. Now this judge, to me, after going through it, because he showed it and cared, Coben Patterson knew about it because he filed the motion and he knew I was telling the truth. But this judge don't even know about this stipulated protective order that Douglas Hanson used his name on to try to conceal my court audio transcripts and stop people from looking into my case. Now, a petitioner by and through his counsel, Coben Patterson, moves the court and order disqualifying the Honorable Daniel Penn from presiding over post-conviction relief trial to assure that petitioner believe that he has received a fair and impartial trial. This motion is made in good faith on the basis that Judge Penn made appearance in petitioner underlying criminal case involved in these proceedings. The motion is not made for the purpose of delay. Opposing counsel, Deputy District Attorney Sean Kellery. And this is the thing, Sean Kellery is such a bad DOJ attorney. He's supposed to be defending Douglas Hanson's bullshit, right? But the thing is, Sean Kellery, I'm talking to you straight in the camera, Sean Kellery. Douglas Hanson did not tell you who I was. He did not tell you how smart I was. He didn't tell you how I followed the paperwork. He didn't tell you how I investigate. You wasn't even a attorney working for Department of Justice. You actually was an attorney working for the Marion County DA's office. Stop it. Go upstairs. All the time now. Go. Shut up. Right now. Take your time. You eating and snacking on everything, but you haven't done no schoolwork. I love you too. I know that. Sean Kellery, we'll get to you later. The motion finds further support in declaration of Colvin Patterson attached here to and competent by this reference. We're going to give you a breakdown of this motion. And I'm going to show all the paperwork. I'm not here to keep on playing. I'm not going to let him go into another year of cheating me out of my rights, cheating me out of my pursuit of happiness, taking away everything, micromanaging my life through my social security number. You keep on putting my number out there for people to call me so I won't answer my phone or possibly change my number. None of that is going to happen. My number going to stay the same, 971-352-9643. Whoever want to call me. That's how it go. And we putting on this information because this is a declaration of Colvin Patterson in support of the motion to disqualify this judge, right? But this judge still saw me through my trial when he knowingly claimed that he put a stipulated protective order on me. Right, I'm counsel for petitioner Matthew Mayfield Johnson Jr. and above entitled post-conviction proceeding. This matter, petitioner challenges the judge of conviction and sentences imposed upon him in State versus Matthew Mayfield Johnson, Marion County Circuit Court Case 14C-42686. Petitioner was pled no contest to delivery of an oxycodone within 1,000 feet of a school, count 1, and promoting a prostitute, count 2, and was sentenced to 36 months supervised probation. That don't even make sense. Since my appointment, I have obtained petitioner transcript, trial court file, and trial attorney file. I have at this point filed an attachment, petition, and trial memorandum on behalf of petitioner. Petitioner prepared for trial in this case. Trial is currently scheduled for September 19, 2019 at 2:30 p.m. with Honorable Daniel Penn. I'm reading all this. I have confirmed with petitioner regarding this matter that allegations raised herein are based on the conviction. ORS 14.260 permits me to file this supporting declaration to establish the requested facts of disqualifying a judge. A judge shall be disqualified when a party believes that that he cannot receive a fair and impartial trial before such judge. And that's what happened here. That's what I knew that my case was gonna be denied because Douglas Hanson cheated. He left the Marion County DA's office because he knew what he did to me was wrong, and he knew I had evidence. If my evidence get on court record and they find out that they really did trial me and all of that, arrest this man. And I'm telling you, I would love to write a victim impact letter to Douglas Hanson because at this moment, he's the suspect and I'm the victim. He really, you can hear it in his, let's rewind Douglas Hanson real quick. You can hear how spooked he is.
I know that there are
That the plea petition is a little overbroad in its language.
Yeah, it is. But we want to
Because
hear
I
it
think
from
the plea
you, Doug.
petition is designed to make sure that people understand things are going to be very limited.
Man, that's a lie. I don't care about nothing.
That's
Gail
my reading
Ryder,
of the plea petition.
Gail Ryder, you just a sleaze bag. You was just on there just.
Your Honor, I know that there are, of course, post-conviction rights that the defendant has that are separate from appeal rights. That's something that potentially is still there. I don't know. I don't do PCR. But if there are claims that the defendant has against his prior counsel, he may be able to file appeals or PCR on that. I don't know. But here I do understand that there's very limited rights in regards to appealing this conviction
he's so
and sentence. If it's an unlawful sentence imposed by the court on the defendant absolutely has the right to appeal.
Yeah, and that's what I'm
Not
doing.
objecting to that.
He said he ain't objecting to that. And that's exactly what I'm doing is the fact that you took my wife and you violated Oregon Revised Statute Code 40.255. That's the reason why I appeal. That's the reason why I'm able to stand up and fight the allegations. But upon review of e-court register, it became apparent that the judge Penn signed a stipulated protective order in petitioner underlying case attachment. Petitioner feels as though he would not get a fair and impartial post-conviction trial given the fact that Judge Penn took action in his underlying criminal case. This is further evidenced by prior motion practice in this case, which include a letter from Kathleen Lovett, right? And she was my mental health counselor, stating that the petitioner feels very unsafe, both physically and socially, psychologically, simply from entering Marion County. Attachment 2, petitioner feels as though his cognitive issues surrounding Marion County would be greatly impacted by Judge Penn, right? Presiding over petitioner's case. And Judge Penn is gonna be presiding over my case no matter what I told them. Like, how is this judge presiding over my case when he played a part in the criminal part of the case? When you think that's a conflict of interest, He's going to save himself. He's going to deny it automatically, and I'm not going to get that help. I'm not going to get the equal protection. I'm not going to get none of that. I'm not going to get none of that. Because of those issues, petitioner did not feel that his case will get the time and unbiased attention it deserves. And if this case is heard by a judge that had anything to do with his underlying criminal case, I do make this motion for proposal of undue delay, and I am currently ready for trial and have no motion to delay and have no motive to delay this case. Defending counsel, Deputy District Attorney Sean Callery, was contacted regarding his position of this matter and does not object. He don't object, but somehow, so who forced him to stay on my case? Who forced this judge to stay? Douglas Hanson doing the favor, I know that. And if you look deeper into this judge Daniel Penn, he was a Marion County DA. He once worked for the Marion County District Attorney's Office. And another thing is, when he worked for the Marion County DA's office as this head district attorney, he was helping smuggle drugs into state prisons. I don't have to tell you what was already out there on public. Just look this man up. And not only that, Ted Kulingowski made this man the director of the Oregon Lottery. This judge is the director for the Oregon Lottery, and he's overseeing my PCR case. But what? Come on now, give me a break. So that's the paperwork. We want to show you that this was the paperwork of the certified of service, and it was actually sent to that DA. And we gonna bust Sean Callery wide open, because we know that you working for the Marion County DA's office. You're not even a DA that works for the Department of Justice. They just got you seeming that you work for Department of Justice when we know where you work at, buddy. You're all gonna be in trouble. All of y'all, I'm telling you. I said this when I was on parole or probation or whatever the fuck they had me on. Douglas Hanson, what are you going to do when the Federal Bureau of Investigation come for you? I can't wait till Biden and Harris take office. Maybe I should take my little black self a trip down to Washington, D.C. with all this evidence that I got. Maybe they'll do what Trump couldn't do. Hold you fools accountable. Just because Biden and Harris is Democrats and this is a Democrat state, don't mean they won't hold their constituent party accountable for their unethical misconduct. That's one thing I do know in following politics. Now, Governor K. Brown had a chance to fix this. Our Attorney General, we asking you to resign. Ellen Rosenblum, please resign. If you let this man Douglas Hanson cheat this bad and then you allow him to assign these attorneys over and over again because he's your chairman for the non-compliant subcommittee of the Victim Right Task Enforcement for the Attorney General, there's a lot that's going on. You say, Douglas Hanson, you don't do PCR, but here it is, you over here cheating me in PCR by using a spy working from the Marion County DA's office on my paperwork. And if you don't believe me, we could just ask the elected DA that took Walter Bigelow's place, Mrs. Paige Clarkson. When I get to breaking y'all down and y'all get to understand it, it's either y'all gonna hold Douglas Hanson accountable or I'm gonna keep on exposing y'all. I'm a private citizen. I have a right to freedom of press. Right? That's my First Amendment of the United States Constitution. Right? I have that right. And you know what else, right, that I'm not invoking because I know I'm not self-incriminating, but I have the Fifth Amendment right too. I'm not self-incriminating. I'm self-telling the truth here. Get to this. Get to why. Oh, is this a minute? The defendant requests the court's transfer venue of basis of. See, every time I had stated or Oregon revised statute code that works in the benefit for me, they denied it. They like nope, because if we transfer his case, turn that light off. I'm not gonna tell you that again. I love you too.
So then, have you put Call of Duty before?
Can you let me finish this?
Okay, then.
Which states the proper venue for post-conviction relief. The court in which the petitioner is currently incarcerated. If the petitioner is not incarcerated at the time of the filing, the county in which the conviction and sentence were rendered. Petitioner does not dispute that on the face of the statute, the proper venue for filing the original petition will have been Marion County. However, petitioner objects to the defendant motion due to the unique nature of the case and petitioner mental condition regarding the genuine fear of Marion County in the court system and parties in that county. Petitioner requests that the court to exercise discretion and deny defendant motion. The subject of the motion is a dispute over venue, not jurisdiction, as the circuit court has jurisdiction over post-conviction claims. ORS 138 demonstrates that where the petitioner is to file a question of venue is provided that release from incarceration should not change the venue of the proceedings of the circuit court in which. So here we go with this. And I got an example to show you because I'm gonna need my example.
So then,
Yeah.
this nigga run. They get asked for.
I done been in this place. I'm so sorry. Tired of being dead lie. We done been here before, don't know. So this is another reason why I ask the courts to disqualify this judge, right? I'm going to switch so y'all can see the paperwork real quick. I'm going to have to take myself out of this equation here so y'all can see what I'm going to be doing. I'm going to show you how Douglas Hanson cheated. He cheated. Remind you, we disqualifying this judge for the sub basis of a stipulated protective order. Now, when my wife was doing a little research, right, she came across the stipulated protective order in which Douglas Hanson used in my case. He didn't even try to change nothing up. He used it word for word for my case. I mean word for word. I'm not gonna lie to you. I was pissed off when I seen this. You see that line right there? That
Yes, Dad.
word for word. He used the stipulated protective order that he got from Lewis and Clark School, where they teach you how to put on a protective order to conceal court audio transcripts. Now, I never, ever knew nothing about this. It was filed in e-court behind my back, and once I start figuring it out, Douglas Hanson was too late because I had already received my whole court audio transcripts. Now, I admit that is my name, but I didn't sign it there. I admit that too. Douglas Hanson filled this out. He went behind my back. I knew nothing about this. There's no transcript. There's no court audio transcript of me ever being in court on this day. He can cheat and he can put in the paperwork all he wants. But the law says a judge got to ask the defendant, do you understand what you're signing? Do you understand this contract that you're signing, Mr. Johnson? Another thing, like I said, this is all the same writing. Let me dab it up some so y'all could see. It's all word for word. My example, where the court has, by the order of presiding Judge Lipscoe's, dated June 5th, 2001, where the court has hereby the order presiding Judge Lipscoe, dated June 5th, 2001. How is this even a part of my case when my case started back in 2014? This is why I'm asking for a disqualification of this judge, is because this judge is claiming that he signed it. And that's now attachment. This is when it's attachment, that is part of my evidence, showing the court that I've been telling the truth. It's up to them to look on the live feeds and see the truth. But I want to get to the signature, because right here, and I'm going to use mine for an example. I'm going to use mine for an example. You see how everything is just my signature? My signature. Let me show you how Douglas Hanson did my signature. How he cheated and duplicated this. He duplicated this contract. He put all of this on me behind my back without me having no acknowledgement. Remind you, I already filed for an appeal for my case. Y'all think I'm bullshitting. Y'all gonna see in a minute. Y'all gonna see in a minute. While everybody else is out there doing whatever, I don't blame them for wanting to get out of Oregon. So right here, you see the little pen mark? Right here, Texas. There's a pen. You see that text? We're just going to duplicate what Douglas Hanson did. And then he went 4. He put 4 in there, right? But I don't like that. Let's get it up to, what do you think it should be? About right there. But see, he wrote it in there. He wrote it in there himself. But in order to make it look so real like a copy, I'm showing you this is the wrong way. All I can do is duplicate the signatures. I can show you how he got those signatures on there. You see that right there? You see that? So what I'm going to do is just fully extend this.
No, I like this house then. This is cool. And this house is absolutely awesome. No, this house is awesome then.
But I want to put it over here. I had duplicated this off of another one that he did. So I got to make it big for y'all. But I want to put the 20 on there. Hold on. I know why it's doing this to me. I want y'all to see the whole thing. Quit being in blue. He cheated my signature.
Yeah, he cheats.
I don't have my regular. This is real serious. How this man was cheating judges. How he was cheating, putting judge signatures. I'm going to use this one again. See, I took a letter and I duplicated it. I might have to go upstairs to show y'all exactly how Douglas Hanson did me dirty. Look, his. And then he'll delete it. Right? Let's get to the second one. Because there's another one. Well, my attorney didn't post the second one. Why didn't he post the second one? So since my attorney didn't post the second one, I'm gonna bring up the second one anyway. I need to go get a photo and show one of my. Let's go here. Let's use this here. And you'll see that I paid attention to everything. So I'm just going to go down to it, and I'm going to show you that these judges that Douglas Hanson used is retired judges. And Daniel Penn, Honorable Daniel, we looking for Lipskos, because you seen Lipskos right here. These judges is retired. So Douglas Hanson tried to cheat by taking away my court audio transcripts. But like I said, I had already got them. They had already been released to me. Once Douglas Hanson found out that these court audio transcripts was actually released to me, he then went behind my back to try to go conceal this. But see, Doug, the thing is, can I call you Doug, or can I call you Corrupted Doug? Right? Either way, Doug, the thing is, you can never beat me to the punch, because I've already been talking to people from the courts, and they released it doing their job. There was no protective order in order to stop them from giving me the information. So we got our example over here, right? This is just the example that we found. Let's go to the top of it, because I'm going to show you from my Cornell notes here, because I got everything. And you see, I'm highlighting and I'm explaining to them that I got examples here. I got true examples. The same thing. I've been using it in all my complaints, is that Douglas Hanson corrupted the paperwork. He put my name on there. Now, people not understanding, like when you go to court and you sign a white piece of paper, it's called a acknowledgement that you was at court, and then your attorney give you the pink sheet. Well, Douglas Hanson lift my signature off that sheet. Don't believe me? Hold on. I'm going to go hold on. Give me 5 seconds.
So then,
I'm going to show you what I'm talking about as far as lifting a signature, but I have to go upstairs, and I'm going to turn on a small camera over here. You'll see me turning on the camera here. You got to go to signature. You see where it says signature at right there. And remind you, Douglas Hanson is working off the same type of computer that I'm working off of. And I spent a long time trying to figure out how this man stole my signature and put it on here and put it on the duplicate paperwork. So where my investigation pointed me towards was looking at the acknowledgement, the court acknowledgement dates when I actually went back and forth throughout the Marion County courts. Not, I'm gonna show you an example here because I'm good at that. I like exposing the paperwork, and we going deep into this because this judge that's seen my post conviction case, right? He basically helped Douglas Hanson. He basically listened to Douglas Hanson, did Douglas Hanson a favor, but they didn't know I was paying so much close attention to Douglas Hanson and his corruption. When I tell you Douglas Hanson is a corrupted guy, he's a corrupted individual. He's corrupted. He's fully corrupted, and I stand behind that. And certain signatures on mine is faded. So what I'm gonna do is give you guys an example. If I could find a pen, we're gonna do it that way because my signatures is like really not looking good here, but I will show you an example of what I'm talking about. Okay, I'm gonna show you an example. So you go to create a signature right here. You should see me popping up on the camera. Hey, that's a cold signature right there. Hold on. That's two. So you. Oops. So what you do is clear that. But this is something that the camera is picking up. So you clear it. And what I'm showing you is a blank piece of paper. Let me clear that. You see the blank piece of paper, right? But this is my court acknowledgement. I kind of like the 3D showing you different poses of me, right? But in this, I'm going to show you exactly how Douglas Hanson left this signature. I'm going to show you. Let me go back and change to Live Me. You see, I had to switch it real quick to Live Me. And I'm showing you that this is the physical paperwork. This is the physical paperwork. And we're going to be lifting a signature. I most definitely took my time doing this. Since this is a copy, my signature is very light. So you're not going to see it. But we will give it a try. And Douglas Hanson had to did this. And what we paying attention to is this information right here. Where did he get this from? How did he lift this? It's got to be somewhere because he's trying to make it seem like I'm the one that's doing it. But I'm not even in Marion County. I have no clue about what a stipulated protective order is. But I know one thing. Let me show you, since this signature is so faded. I got to put this one back, and I'm gonna give you an example of how he did that. I'll give you an example. I need a piece of paper. Please excuse me. I need a pen. I got things that I wanna tell you. Won't you be me? So in fact, that is my signature. But there's no way I've ever wrote this part. I never had to write my case number down. That's what the public defender is for. So either the public defender is at fault or Douglas Hanson. But I never signed this. I never ever once signed this. How they got my name on there is just you gotta look at all the evidence. You gotta look at all of it. Now, I'm telling you above me, in my camera, all the evidence point towards me telling the truth. And I've never ever seen such corruption in a judicial system. If the prosecutor is using these kind of tactics to cheat you out of your appeal rights and to make sure that they get this 100% A1 title as far as prosecuting, oh no, that it doesn't meet the qualifications of actually being able to stay in office. And that's exactly why they retiring and they leaving, and they not wanting to give me no recognition because of the fact, right? A blank piece of paper. We're going to show you how the prosecutor did it, how Douglas Hanson did this behind my back. Like I said, I am not an attorney, right? So I would never ever have the resources or the access to be able to bring up such a document such as a stipulated protective order, right? So what Douglas Hanson did was took one of my things, 14C 42686, right? This is how he did it. And then, so all I'm doing is one line at a time so I won't be confusing y'all. Y'all see me write that on the piece of paper right here. Y'all see me write the case number. So what I want to do in order to make it, in order to get that on here, I got to bring this and let the camera catch it. And I don't kind of like that one, so I'm going to clear it. I want to give y'all a good one. No, that's not. It takes practice.
What the? Bro. Yeah. The body? Who was thinking that? What's wrong with Steve?
Maybe I should. Hold on. Maybe I should use a black pen, but it should be able to work with a blue pen. Maybe I'm not pressing hard enough.
The one for this. The pineapple.
Okay, this should be it right here, guys. I kind of like that one. I'm trying to make it as close. And then what Douglas Hanson would do is put that right in here. You see how it kind of it fits on that line?
What's up, nigga? What's up? What's up?
I think I'm gonna just shrink it a little bit. I could bulge it, whatever, but I wanted to make it look like as if, see, I can extend it and make it bigger, but we wanted to get it right where Douglas Hanson got it. It's a little bit more than this up. And that's what I'm saying. Anybody can do this. And then he wrote state right here. Yeah, he wrote state. And I'm gonna make sure I darken this. Right? Again, you see me put the state right here. And what we're gonna do is come right back up here to the signature, and we're gonna go to create a signature one more time, and we're gonna pick up state. I like that. Ah, dang it.
That's mine.
Why do it do this to me every single time? I had it so perfect. This is so irritating. I'm gonna go this way with it. See, it's just
Those turns. What again?
if I use that one.
What again? Huh? Turn again?
That's all this man is doing. State. And then let's write my name the way I probably wrote. That is my way I write my name. And then I went, and you see what I'm doing. I'm lifting my signature as if I signed my acknowledgement papers. We gonna get through this. Create a signature. Put it right on the line. And he don't care how it look. He really don't care how it look. I hate when I do it. So basically, we duplicating. I'm just showing you. I'm not gonna be all precise with it, like how Douglas Hanson was for me, but you get the drift here. So we're gonna move down to the second part of this where he again lift my signatures, and I don't think I got a stipulated court protective order here to show you guys how he because I can't actually steal a judge's signature, but somehow I got them on my computer. And I think that's in my other book. Yeah, that's in my other book. So we're going to move to the second part of this. And give me a minute. I got to go change books. I got to go get a different book. I have to go get a stipulated protective order. This, where would this be at? I know exactly where it's at.
Oh, I know where.
Hey, stop playing with that. I know of a plan.
I love you, Dad.
I love you too.
Have you heard the ice cream in the store or no?
Dang, I think I grabbed the wrong one. Yeah, I grabbed the wrong one. I gotta show you exactly how he left these judge signatures. I thought it would maybe be in this one. Don't tell me I'm going up there for nothing. Yeah, I grabbed the wrong one. I should have grabbed the royalty folder. Ah! This one, for sure, got it. For sure. Boom, boom, boom. I'm going to show you how he left this judge signature. Right? This. We're going to take this signature. Hands off. I got his own copy, his paperwork. I got Douglas Hanson paperwork, and this is why I'm saying it's prejudice on somebody. You gotta know what's going on, because for one, I'm not no attorney. What's my Oregon State bar number? Why would I print my name there when it clearly says Oregon State bar name? So that means the attorney had to have. I wasn't representing myself. He didn't want to get Gail Ryder in no more trouble. But anyways, so we come over here because I can't actually pull that signature, so I got to get it somehow. So I'm going to do a Douglas Hanson trick. I'm going to go right here to signature. Again, I'm going to go to sign, create. Put that.
How long he did? Then I'm too. Dad, we need to say. We need to make a phone again.
Must I show you any more of how this man did me? Must I show you any? It looks as if somebody did this, right? If I can do this, and I'm just giving y'all a little example of how I just lift that signature of a judge, I basically can prosecute anybody. With the knowledge I got, I could e-file, e-court, do everything that Douglas Hanson did and bring somebody to court and not have no evidence. Just put that person through mental stress, saying that he or she got a court date. This signature that Douglas Hanson stole, I just stole it myself, and I put it right on a blank piece of paperwork. And he also stole my signature by doing the same thing. He did the same thing. And I can show you, because right here on this example, I will sign my signature the way that I normally sign a signature. Right? I will sign, let me get it on this piece right here. I sign my name the same way. Now you see this piece of paper right here. I'm going to go ahead and lift my signature and put it on there. I'm showing you why it was I told my post-conviction relief attorney Coben Patterson a motion to disqualify this dude Douglas Hanson because he's been cheating. He's been taking my acknowledgement letters and he's been lifting my signature and he's been putting it on duplicate information. Look, watch.
Stay out of there. You shut.
It's this simple.
Then freaking pickle juice all over my freaking shirt. Why he did that? No. Pickle juice?
It's looking like I'm signing everything, huh?
Dad. He just put.
Then he put my name, Matthew Mayfield Johnson, Matthew M. Johnson Jr. Cause he gotta make it seem like I'm the one that's signing it, right? So, and I'm signing mad too. I'm signing mad. So this is what he's doing. He's getting my acknowledgement paperwork and he's going to his little creative signature and he's, oops. I gotta get it off. Maybe, hold on. Maybe this too far to,
But do you got rock? Oh, I know, I did. I could download rock so I could play it.
cause it gotta be semi-close. So we're gonna try this one.
Rocket League? Yeah, rock. It's not called rock, it's called Rocket League. Yeah, the Rocket League. I could download it.
Oh, I need it in the middle of the paper? Dang.
Hi, Dad.
Can y'all let me do this or what?
Yeah. Hey, run around the house.
Quit shaking my chair. Move. Let's just use that one. Because I'm spending too much time. Or I can go up on it. It's looking like I'm signing shit, huh? It's looking like, and Douglas Hanson say, hey, I ain't do that. I didn't do that. He signed it himself. Then he put a 4 there. Then he put November. Yep. He put November. What? Of 2014.
I didn't do anything. That was fun.
It's looking like I signed this when really I didn't. Now, Douglas Hanson can do this when we got a 17. Douglas Hanson can do this to so many different people. So many. I could put the 17 on there. What I'm going to do is, let's put that 17 on there. This should be easy. I like that 17, how it came out. It almost looked identical to Douglas Hanson's, but kind of far out, kind of. But y'all get my drift. I'm not gonna do all of that. I wanted to show y'all this. And he just cheated, man. He just really cheated. Look at it. Just look at the evidence. Look how I'm just deleting everything that this man did to me. I'm deleting it all. I'm deleting it all. And that's why I put void out. Void this out. And he did another one, and I have to show you that when I found out that he did this wrong and this one wrong improperly, because he's putting my name on this stuff. And I'm showing you exactly how he's putting my name on. This prosecutor, you mean to tell me this prosecutor that dangerous that nobody want to do anything about it? Even if I die, I mean, this being shared wherever, I'm putting out the truth, right? You mean to tell me that this man get to forge 2 different judge signatures, and I think I got this judge signature already on record. Nope, I don't. Let's get rid of some of this stuff and use this one right here because I got it on record. And what we want to do is bring it all the way up. I love you too. And it just don't. I want it. Maybe it's. And what you see me doing is adding the name up in the lines. Because I ain't going to go digging in the book to try to do this again.
What?
I normally go off that
I can't
too.
hear what you're saying. No, this. What? You want to take your shirt off? Yeah.
Why?
Because it's getting sweaty. And I don't feel like wearing this. That's all the Don't hurry, okay?
This is why there's a motion to disqualify this judge. Now let's move on, because I spent a lot of time on this. We're gonna get off of this. And, we back at the motion to disqualify the judge.
Begin. This is case number 18 CV 17382. This is a trial, post-conviction petition, and both counsel and petitioner are present in the Marion County courtroom. I am appearing by video, and I can see the witness chair in the Marion County courtroom. And I've had an opportunity to review the memos and exhibits that have been put forward. Let me ask Mr. Patterson, I see that you have, is it 1 through 14, or help me with your exhibits?
Yeah, petitioner would offer exhibits 1 through 14 at this time, Your Honor.
Is there any objection?
None, Your Honor.
All right, I will receive petitioner's exhibits 1 through 14. And then I saw one exhibit for the state, which is 101, but there are a lot of pages attached to that. I think it's something like 78 pages or so.
That's correct.
Okay, and so you're offering that one exhibit?
That is correct, Your Honor. State offers that at this time.
Okay.
Because he ain't got nothing
Okay,
else.
is there any objection to 101?
No objection, Your Honor.
All right, I will receive defendant's 101. Is it anticipated that there would be any testimony today?
Yes, Your Honor. We'll be calling Matthew Johnson Jr. as a witness. That's it.
What about my
Okay.
wife? See, that
Will the defense be calling any witnesses?
show.
Your Honor, we will not.
What about Gail
All right.
Ryder?
Thank you. So we are at the point where I have received all the exhibits as evidence, and so those are in the record and available now. But we also are going to have Mr. Johnson testify. So I'm going to need Mr. Johnson, if you would walk up to the witness chair, please. And when you get up there, I want you to raise your right hand, and I'll give you an oath to tell the truth. All right, Mr. Johnson, under penalty of perjury, do you solemnly swear or affirm that the testimony you will give today in this hearing shall be the truth and nothing but the truth?
Yes.
Yes. Yes,
All
I
right,
do.
please be seated.
Well, I'm already seated. This is reenactment.
And we'll have you start out by saying your name for the record and spelling your last name, please.
Matthew Mayfield Johnson Jr., Johnson.
All right. Thank you very much. And now, Mr. Patterson, you may ask questions.
Thank you, Your Honor. Mr. Johnson, were you listed as the defendant in Marion County Court case number 14 C42686?
Yes.
And what were you charged with in that case?
Unlawful delivery of an oxycodone within 1,000 feet of a school and promoting prostitution.
And in this post-conviction case, are you challenging the constitutionality of those convictions?
Yes.
Were you represented by counsel at the time of the underlying convictions?
Yes.
And how many counsel were you represented by?
About 5 or 6 of them.
Who was the last one in that chain of counsel?
Gail M. Ryder.
And during Miss Ryder's representation of you, did you have a chance to meet with her face to face?
No. Well, can you rephrase that? Because I met with her initially when she was initially appointed to me.
Okay, so
To be exact, I had one office visit with her.
one office visit. What about after that? Did you ever meet with her again?
No,
How did you communicate with Miss Ryder?
through emails.
And how did that come about? Why were you only communicating through emails?
She stated that she didn't trust me and that I wasn't honest with her in our meetings, and she just felt like she couldn't work with me.
Did you feel throughout her representation that you were able to promptly get a hold of her?
No.
And upon meeting with Miss Ryder, how did you tell her you wanted to resolve your case?
I told her right when she was appointed to me that I wanted to go to trial.
Mm-hmm.
And did you
It's
guys
gonna
start
be
marching
good,
towards
guys.
trial?
Well, at least I thought I was. That's what was said to me in the emails, is that she was preparing for me to go to trial.
And communicating through email with Miss Ryder, did you feel as though you were understanding the
No.
things that she was explaining to you?
No, absolutely not. There was a lot of confusion and contradicting things that were said between the emails.
And you have the exhibits in front of you?
Yes,
that
I do.
Attached to your trial memo. Can you look at Petitioners Exhibit 13, please?
Hold on.
Tell me when you're there.
Hold on. We're going to get to the trial memo. What we're going to be doing is going over a lot of paperwork, and I'm going to be stopping and pausing through here because this is basically my trial memo right here, post-conviction relief proceedings, right? Since they wanted to cheat me behind the public back, we're going to go ahead and put it on public record. I should do this one not attached to this, but it's part of my live stream anyway, and then I would do like a solo one later with just this transcript and it playing by itself. But hey, I'm going to chop it down. I gotta come back a little bit here.
Said between the emails.
And you have the exhibits in front of you?
Yes, I do.
Attached to your trial memo. Can you look at Petitioners Exhibit 13, please?
Exhibit 13.
Tell me when you're there.
I'm there.
You recognize that document?
Yeah, this is a document from David N. Sweet, a doctor, which
Hold on, I gotta get.
Please. Oh, Dad! Dad, look!
Hold on.
I was the figure.
I gotta find that for y'all, or I ain't gonna be doing my job right.
I'm there.
You recognize that document here?
Said between the emails.
And you have the exhibits in front of you?
Yes, I do.
Attached to your trial memo. Can you look at Petitioners Exhibit 13, please?
Exhibit 13.
Everyone does.
I guess I'm not. Let's just play it.
Tell me when you're there.
I'm there.
You recognize that document?
Yeah, this is a document from David N. Sweet, a doctor, which Gail Ryder had sent me to.
So did you have a meeting with Mr. Sweet?
Yes, I did.
Okay. Is that the report that he generated as a result of that meeting?
Yes, it is.
Are you familiar, or can you flip to Petitioners Exhibit 11 for me, please?
It's backwards, sorry.
That's what happened then.
You say 11?
Yeah.
All right.
How about this one?
Here.
There?
Yes.
You recognize that document?
Yes, I do.
Have you read the contents of that document?
Yes, I have.
Did you, at the time of your underlying trial, were you able to have contact with your wife, Jessica Johnson?
No, I was not.
Were you aware of the contents of that declaration during the underlying proceedings of trial?
No, I was not aware of it.
Did you understand how that content could be used as a defense in the underlying trial?
No, absolutely not.
And Mr. Johnson, did you and Ms. Ryder ever discuss uniform criminal jury instructions?
Oh, she sent it to me in email, and that was it. She never made a phone call to discuss it or anything. And my understanding at the time was because the emails was coming so frequently that anybody could have sent the email. So I wasn't really understanding why she never allowed me to meet up with her to talk about the actual jury.
So did you understand the possible jury instructions that could be presented at trial based on those email communications?
No.
How did you ultimately resolve your case, Mr. Johnson?
I eventually took a no contest plea. I just gave up, and it had streamed along for so long that I felt like I was backed in a corner. So,
And what was your understanding at the time that you pled in regards to your right to appeal?
well, as a part of my agreement with Gail Ryder, we had a conversation in a hallway where I asked her about the motions that my previous attorney, David Kuhn, had filed. And she told me that those were preserved for me, and that if I took the no contest plea offer, then I will be able to preserve those rights.
So at the time that you pled, are you saying that you thought you had the
Appeal rights, yes.
Okay.
So right here, we're gonna show you what Colvin Patterson is talking about as far as Gail Ryder and the appeal rights.
Rights of appeal. You're taking the deal, and that's that.
And that's not what Miss Ryder just explained to me in the hallway. I literally asked her if I could appeal within 30 days, and she told me yes.
And if I may, Your Honor,
Sure.
I think that the statement in the plea petition is a bit too literal. Under current law, a person is entitled to file a claim for appeal or a notice of appeal if they can state a colorable claim for the appeal. Now, I know when you enter a plea, whether it's guilty or no contest, those rights can be very limited. But if the public defender's office, after consultation with Mr. Johnson, can find a colorable claim for appeal, then a notice of appeal could be filed, notwithstanding what the plea petition says. That's my understanding of current law. So while he has limited appeal rights, he still does have some appeal rights.
So let's get back to Colvin Patterson explaining how Gail Ryder told me that I have appeal rights.
And you went over a plea petition with Ms. Ryder, is that right?
Yes.
At the time that you were going over that plea petition, Is that when she was making those representations to you?
Yes.
Okay.
It was actually on the initial date that I took the plea that she brung out the plea petition. She never ever talked to me about it in emails.
Okay. So I think you touched a little bit on why it is that you pled no contest to these charges. Do you think that you had a right at that time to go to trial? Or
Yeah, absolutely, I did.
You did?
Yeah.
Why did you enter no contest pleas then?
Because I was told if I entered the no contest plea, I would be able to sue Kerry Weiland for taking away my initial preliminary hearing rights.
Okay, let's pause it right there. Let's pause it right there. And I'm gonna use her emails because eventually we're gonna. I knew I should have had this out, but. This was bad idea going this way. Let's see if I can find it. So this is an email from Gail Ryder, and since they want to put me under motions, let's bag this up a little bit.
Yeah, absolutely, I did.
You did?
Yeah.
Why did you enter no contest pleas then?
Because I was told if I entered the no contest plea, I would be able to sue Kerry Weiland for taking away my initial preliminary hearing rights.
I know you continue to be upset because you did not get a preliminary hearing. Pleading no contest to the drug charge does not mean that you cannot pursue a civil suit against Kerry Weiland if you want to.
And what about contact with your wife and children?
She said that I would immediately have contact with my wife and my children, and that I wouldn't be labeled a sex offender. And that was initially what led me into appealing the case, because they stuck me with the sex offender.
I could save you from prison, but you must be willing to enter a no contest plea to the delivery of an oxycodone charge. The DA will recommend probation. If you do, you will be back with your wife and your family, and the charge of promoting prostitution will be dismissed. There's no doubt that the text evidence together with the pills you have proves to a jury that you were trying to sell oxycodones to Nicholas Peter. You will be found guilty for that charge. Why not plead no contest, get probation, be done with this nightmare that come into your life? There will be no restrictions on your contact with your family, and you will be not labeled a sex offender. Turn that down, man. let's get back into this.
When they told me that they would drop the promoting prostitution to get me to plead to the delivery of an oxycodone, and I would be back at home with my wife and children.
You feel as though Miss Ryder coerced you into pleading?
Absolutely.
Yeah.
She gave me until 5 o'clock to accept the state's offer, when previously, earlier in that day, I had been explaining to her that I didn't want to take the deal. I was already ready to go to trial, but she would never allow me to put on any type of evidence.
Okay. Just a few more questions, Mr. Johnson. If you understood that you did not have a right to appeal, would you have pled guilty or no contest?
No.
If you understood the possible defense and uniform criminal jury instructions that you had at your disposal in relation to your wife's potential testimony, would you have pled no contest to these charges?
No.
If Gail Ryder did not coerce you, as you said, into pleading, would you have pled no contest to these charges?
No.
Okay. Thank you. Nothing further, Your Honor.
All right, cross-examination.
Mr. Mayfield,
Yes.
you've had, as you testified, a number of attorneys in this case. Is that correct?
Yes, sir.
All right, and you actually communicated with most of those attorneys in lengthy emails. Is that correct?
Yes.
And so it's not unusual for you to communicate with your attorneys in emails. Is that correct?
That's what they put on me. I was always making an effort to try to meet in person with them. I actually met with David Kuhn, on 3 or 4 occasions, twice actually. And I've met with Jessica Kempfee once, and I've met with Kerry Weiland twice.
Right, with that, you did communicate emails, and the email address you used were the emails that Gail Ryder was using. Is that correct?
Say that again?
Email address you used are the email address that Gail Ryder sent you those email addresses to, correct?
Yes, yes.
All right, I have no further questions for you.
What?
Any
Look at that. So what we're gonna do is pull this over here now, and we're gonna bring up Gail Ryder's declaration letter, and we're gonna go over that real quick. Declaration. This is why you defendants don't have no credibility going up against a judge. Like Gail Ryder was more than just a public defender to me. I, Gail Ryder, do declare the following. I'm attorney licensed to practice law in the state of Oregon beginning in July of 1993 and until my retirement of December 31st, 2017. I practice criminal law from September 2008 until September 2nd, 2011. I worked in Marion County as a hearing referee pro tem judge for Oregon Judicial Department, which meant she knew better. She knew to illegally prosecute me, this will come back and haunt her. But she went on, even though she had a good career. Gail Ryder had a very good career. She was real well respected, and when she found out that I wasn't gonna stop fighting for my life back, and she was tangled up in this crap, she went ahead and retired. And let me tell you, the reason why they retired like that is because they feel like they can keep all their assets, because after I sue the state, I get to turn around and then sue each and every one of them in their own individual capacity, especially Douglas Hanson, especially him. I'm suing him for every little thing he got. All the little St. Lucia trips that you took on illegal convictions, and all the things that you doing, how you even stealing from your own nonprofit organization, right? Now listen to this. I have represented clients on charges ranging from minor misdemeanors to murder.
Hello?
Hello?
Oh, hi, Mr. Johnson. This is Hollydale School Counselor.
I was appointed to represent petitioner on March 10, 2015 on the charges of promoting prostitution delivery within 1,000 feet of a school. I believe I was petitioner's fourth attorney appointed by the courts based on petitioner criminal history. Each charge carried the 35 to 40 months presumptive prison sentence with a possible directional departure to directional departure up to 80 months in prison. 80 and 80 on both charges, which I was telling you guys about. Based upon my review of police report and petitioner case, the state's evidence at trial will likely include a list of the following information. Salem Police Officer Roger Smith hereinafter Smith will testify that on May 15, 2014, he was reviewing Backpage.com for possible prostitution activity in the city of Salem. And this don't even seem like it could be Gail Ryder doing this. This is Douglas Hanson doing this for Gail Ryder while she's retired. Gail Ryder have no clue what because this is the same reading. Let me get you to something like so I can show you. And they already lying. We got to keep in mind that Douglas Hanson is controlling this, and this is the information that Gail Ryder is trying to testify to about Roger Smith in her own declaration. Salem Police Officer Roger Smith will testify on May 15th, right? Well, if that's the case on May 15th, and I go here, I got to use all of my power right now. So this, I'm gonna play court audio.
So at least there was evidence.
It was evidence
That she was in Salem.
Yeah, that's it. That she was.
Yes, the 15th.
Yes.
And she indicated as such in that ad that she had placed.
You hear what Susan Tripp said? At least there was evidence of her in Salem on the 15th. Now, Gail Ryder's declaration is just fraudulent. And that's how I know somebody else is doing it, is because it's reading contradicting to what's on court audio transcript. Susan Tripp herself said it. I'm going to play it one more time. I'm going to turn it down a little bit.
So at least there was evidence.
It was evidence
that she was in Salem.
Yeah, that's it. That she was.
Yes, the 15th.
Yes.
And she indicated as such in that ad that she had placed.
Douglas Hanson said it was her. Tripp said it was evidence of only her being there on the 15th. But Gail Ryder's declaration letter in my court PCR is saying something different under her declaration. Salem police officer would testify that on May 15, 2014, he was reviewing Backpage, looking for possible prostitution activity in the city of Salem. He initiated a text communication with the woman he believed was a prostitute based upon her advertisements on Backpage.com. The text conversation included several services that the woman offered and cost for those services. So you jump down here because this is Roger Smith original police report right here. And I can prove my wife never got this police report because they said limited investigation, lack of da-da-da, right? They cheated my appeal, period. I'm going to show y'all. On May 15, 2014, I was viewing Backpage for potential prostitution activity occurring within the city of Salem. Backpage.com is a website used for the listed items of or services for sale. The website allows unrestricted access for users, sellers, or potential buyers to sell a specific state and city and select a specific category to search or post an advertisement. I know from my training and experience that these advertisements under the escort section is commonly used for prostitution activity. I have personally conducted investigations from these and similar advertisements which have resulted in the arrest and conviction of female prostitutes, not male. Not female prostitutes, which have resulted in arrest of conviction of female prostitutes and Johns. I know from my training and experience that the term John is a term used for males who solicitate prostitutes for sexual services. Her whole declaration is this police report. On May 16th, approximately 1 p.m., Smith and detectives Lance T. Dede, who is that, together with members of the Salem Police Department Street Crimes Unit went to the Shiloh Inn on Market Street in Salem. Smith knocked on the door. It was answered by a solicitous clothes woman, immediately recognized by Smith as the woman in the pictures from the Backpage advertisement. The woman was identified as Jessica Uriah Johnson. As Smith walked into the room, identified himself as a police, the officers followed him into the room. Exhibit 1. So basically, they basically put the whole police report over under Gail Ryder's declaration. So what we gonna do now is go to, dang, this is a lot of work. I didn't realize this was so much paperwork. We're gonna go over to these emails that this prosecutor was talking about, Sean Callery.
If you understood that you did not have a right to appeal, would you have pled guilty or no contest?
No.
If you understood the possible defense and uniform criminal jury instructions that you had at your disposal in relation to your wife's potential testimony, would you have pled no contest to these charges?
No.
If Gail Ryder did not coerce you, as you said, in the pleading, would you have pled no contest to these charges?
No.
Okay. Thank you. Nothing further, Your Honor.
All right, cross-examination.
Mr. Mayfield,
Yes.
you've had, as you testified, a number of attorneys in this case. Is that correct?
Yes, sir.
All right, and you actually communicated with most of those attorneys in lengthy emails. Is that correct?
Yes.
And so it's not unusual for you to communicate with your attorneys in emails. Is that correct?
That's what they put on me. I was always making an effort to try to meet in person with them. I actually met with David Kuhn, on 3 or 4 occasions, twice actually. And I've met with Jessica Kemphy once, and I've met with Kerry Weiland twice.
with that, you did communicate emails, and the email address you used were the emails that Gail Ryder was using. Is that correct?
Say that again.
Email address you used are the email address that Gail Ryder sent you those email addresses to, correct?
Yes.
I have no further questions for you.
Any redirect?
Just
Mr. Patterson?
very briefly, Your Honor.
Sure.
Mr. Johnson, you said that you had an opportunity to meet with Mr. Coombs face to face.
Yes.
Did you feel that was a more effective way to communicate than emails?
Absolutely.
Nothing further, Your Honor.
All right, Mr. Johnson, you may step down now and go back to the council table. And as I understand it, the petitioner does not have further witnesses. Is that correct?
With that and the exhibits and contents of the trial memorandum, petitioner is resting and moving to the argument.
Okay. All right, and I'd already heard the defendant does not intend to call witnesses.
That's a lie.
So, Mr. Johnson, at this point, we have all of those exhibits as documents in the record
They missing
and
some.
your testimony, which you just gave. Now, the lawyers are going to make their closing arguments.
This dude
Those
is
arguments
so
aren't
corrupted.
evidence, but that helps the court understand all of these documents. And with that, Mr. Patterson, you may begin. And I would say that petitioner also has a right of a brief rebuttal argument as well. So, Mr. Patterson.
Right, thank you, Your Honor. For the most part, we'll be relying upon the arguments in our trial memorandum, but as I always do in these cases, I'd like to go over a few of the salient points here in case you have any questions for me. Essentially, what petitioner has done is raise 5 claims. Claims 1 and 2 and 3 or 4 are really just bifurcated claims that have been parceled out for purposes of preserving the right to appeal. And then we finally have one additional claim, and I'll go through each of those.
Oh, we have no right
basically
to
as
preserve.
claims.
None.
Claims 1 and 2 discuss that trial counsel was ineffective for failing to properly admonish Mr. Johnson about possible defenses that were available to him, jury instructions in support of those offenses, and the testimony that his wife, Jessica Johnson, the alleged victim in this case, would be willing to present before a jury. Trial counsel knew that petitioner's wife intended to make favorable statements at trial. That can be seen through her file in the declaration. That position, as far as Ms. Jessica Johnson is concerned, still hasn't changed. Can be seen in Petitioners Exhibit 11 that she is still willing to present favorable testimony and would have if she was subpoenaed for trial.
Then why did he call
Trial
her?
counsel throughout the representation, likely in an attempt to shield herself from wasted time, decided to use email as a primary form of communication. I believe from her declaration she has formed the opinion that Mr. Johnson was a difficult client and decided that it was better for her best interest to communicate through email throughout her representation. And quite frankly, that decision is extremely inappropriate. She asked petitioner not to contact her at times so that she may prepare for trial. Also inappropriate to turn your client away when that client has questions about their rights that you're trying to represent moving forward. It's very concerning behavior, and especially when we're dealing with complex legal principles at play, and in relation to Petitioners Exhibit 13, the evaluation of Dr. Sweet, which the trial counsel was familiar with and understood the concepts within that report. and in relation to Petitioners Exhibit 13, the evaluation of Dr. Sweet, which the trial counsel was familiar with and understood the concepts within that report. That is kind of summarized in pages 14 through 15 of Petitioner's trial memo of kind of the assertions that are made in that report and the concerns that a trial counsel should have had upon reading that document. This has been given communicating via email is given less attention than you would to average client. And based on Dr. Sweet's report, it should be the exact opposite. This is an individual that should have been given more attention than the average client. Petitioner did not understand how his wife's testimony could be used to defend him against the charges against him. He didn't understand the legal principles that were at play, the jury instructions that we presented to the jury, the mens rea requirements of the crimes, how that testimony would fit in light of his defense at trial in front of the jury. It's clearly an ineffective assistance of counsel to ignore a client with these sort of deficits and cast into a pool of email contact only, which was not sufficient for Mr. Johnson to understand the legal principles at play. Those principles are outlined in pages 15 through 16 of Petitioner's trial memo. The prejudice from this is clear as day. Mr. Johnson took the stand and he told you, Your Honor, that he would not have pled no contest if he understood the existence of the potential testimony from his wife, Jessica Johnson, if he understood the legal principles at play, if he understood how those legal principles could be used to defend himself, if he understood the jury instructions and what the jury would be asked to do in light of that testimony. Also, without a firm understanding of those legal principles and the available testimony to him, he could not have made a knowing, voluntary, and intelligent decision to waive his constitutional rights, both state and federal, in order to resolve his case with no contest pleas. Claims 3 and 4 discuss the fact that Mr. Johnson was not properly advised of his right to appeal. I think it's clear looking at the trial court record from the transcripts, as well as Mr. Johnson's testimony here today, which coincide with that understanding of the transcripts. Not only did Mr. Johnson think that he had a right to appeal, trial counsel stated on the record that she told him that. And Judge Tripp was disagreeing with her, and trial counsel fought with Judge Tripp and said, I disagree with you and your reading of the plea petition and your understanding of the laws. What Ms. Ryder, trial counsel, was advising petitioner was erroneous.
Let's stop right there and go back to what he's explaining as far as Gail Ryder arguing with Susan Tripp.
Yes.
And if I may, Your Honor?
Sure.
I think that the statement in the plea petition is a bit
Come out of a presumptive prison sentence that you might face if you went to trial. You might be found not guilty at trial, but you might end up facing a presumptive prison sentence. So, here's the question. You're signing a document as part of your plea that you're giving up all rights of appeal. You're taking the deal, and that's that.
And that's not what Ms. Ryder just explained to me in the hallway. I literally asked her if I could appeal within 30 days, and she told me yes.
And if I may, Your Honor?
Sure.
I think that the statement in the plea petition is a bit too literal. Under current law, a person is entitled to file a claim for appeal or a notice of appeal if they can state a colorable claim for the appeal. Now, I know when you enter a plea, whether it's guilty or no contest, those rights can be very limited. But if the public defender's office, after consultation with Mr. Johnson, can find a colorable claim for appeal, then a notice of appeal could be filed, notwithstanding what the plea petition says. That's my understanding of current law. So while he has limited appeal rights, he still does have some appeal rights. I think that the plea petition is a little overbroad in its language, because I think the plea petition is designed to make sure that people understand things are going to be very limited. That's my reading of the plea petition.
Your Honor, I know that there are, of course, post-conviction rights that the defendant has that are separate from appeal rights. That's something that potentially is still there. I don't know. I don't do PCR. But if there are claims that the defendant has against his prior counsel, he may be able to file appeals or PCR on that. I don't know. But here I do understand that there's very limited rights in regards to appealing this conviction and sentence. If it's an unlawful sentence imposed by the court on the defendant absolutely has the right to appeal that. And we're not objecting to that.
Only did Mr. Johnson think that he had a right to appeal. Trial counsel stated on the record that she told him that. And Judge Tripp was disagreeing with her, and trial counsel fought with Judge Tripp and said, I disagree with you and your reading of the plea petition and your understanding of the laws. What Ms. Ryder, trial counsel, was advising petitioner was erroneous. Essentially, he had waived all his rights to appeal, and he did not understand that at the time that he was entering no contest pleas. As a matter of fact, in the transcripts, I believe what he's saying is, I'm just doing this so I can go home to see my wife and kids, and I intend to continue to fight this, showing that his understanding was that he could, in fact, appeal that based on the motions that Mr. Coons had filed and other aspects of his case. And he was not making a knowing, voluntary, intelligent to plea no contest on that basis. It was clearly an effective assistance to counsel to advise Mr. Johnson that, likely to just get him to go ahead and fold no contest so she could get rid of his case. And on those basis, petitioner is entitled to a reversal and remanding of his convictions and sentences back here to the Marion County Circuit Court for further proceedings. Finally, Mr. Johnson told you on the stand that he felt as though Ms. Ryder coerced him into pleading no contest, which I think also looked in the context of petitioner's third and fourth claim for relief, I believe is pretty apparent on the record. He would not have pled no contest if it wasn't for that behavior of trial counsel. And so for that reason, he's entitled to post-conviction relief on his fifth claim as well.
Let me ask you, from looking at the transcript, do you agree that Judge Tripp told the petitioner that he really, in practical terms, doesn't have a right of appeal?
I think if you look at that the colloquy as a whole, Your Honor, is that yes, there was something along those lines mentioned. However, if you place it into context with Dr. Sweet's report, the representation that trial counsel is making on the record along with Judge Tripp, at some point that conversation just kind of fizzles out. I don't believe that it was entirely clear, especially true given the light of Dr. Sweet's report to individual with some of the problems that Mr. Johnson has.
Mr. Johnson testified today, and he had earlier made statements. Let me see. How should I phrase that?
Lying, straight up lying.
How would you agree that the Dr. Sweet's report was done on the issue of aid and assist?
I believe that's why it was done. Yes.
Yeah. Now, what about that report? How would you use it differently than establish that Mr. Johnson was able to aid and assist?
Well, Your Honor,
when you're saying trial counsel made error here when she had Dr. Sweet's report, and yet her legal opinion was this no contest plea at this deadline. If we miss this deadline, this plea is gone. And that's, I guess, practically speaking is coercion, and yet I don't think it's legal coercion. It's just, hey, you got a deadline.
No, that's coercion.
But
Ain't no
how
in-between.
else? Why is it error to receive this report and acknowledge that your client can aid and assist? How else would you use it? I guess that's my question.
Well, and Your Honor, I guess for clarification, are you talking about in general, or are you talking about in relation to specific claims? Because I think
Yes. In this case,
yes.
I'm saying if I had this report, and so he's able to aid and assist, but you're saying, well, but there's all this other information here. So how should she have used it if you're saying she made
To
an
defend
error
me,
by
motherfucker.
misusing it? I get, and
There was
maybe
other
that
shit
isn't what
in
you're
there. They was
claiming.
applying
Maybe that's
mental
just a
pressures
bad
on me.
question.
I wouldn't say it's a bad question, Your Honor, but it's not what I'm claiming. What I'm saying is that, and I think you mentioned my first point, which is if a report is simply to communicate he's able to aid and assist, that report would be about 5 words long. That's not what happens in aid and assist reports. It gives an in-depth psychological diagnosis. It talks about possibility of an individual not being able to process information at the same rate as another individual, that some forms of communication may be better than others.
Right.
And upon reading the entire report, not just the last sentence that says he can aid and assist, knowing those psychological issues are at play, trial counsel had a duty then to follow through and properly explain things in light of knowing that knowledge. A simple email communication with complex legal principles and not meeting face-to-face, that's the inappropriateness when you understand that this is an individual that needs special attention to communicate some of these issues.
Right.
Okay.
That's how it fits.
And that's help. Yeah, that is helpful
No,
to
it
me.
ain't.
I guess.
No, it's not.
And I'll just
You
ask
still
this
deny
one.
me.
I was wondering if maybe you thought this was a sufficient report that she should have done mental disease defense or something like that, but it doesn't sound like that's what you're
So
saying.
am. Because
No, that's not what
I
I'm
don't
saying,
have
Your
a
Honor. I'm
mental
just saying-
disease.
Okay.
These fools is crazy, man.
No, I understand that, and saying she should have
What,
done
Judge?
more to explain this.
So
Okay.
shoulda. She's my fucking public
All right.
defender.
Did my questions generate anything else you wanted to say at this point?
He
Mr.
laughing.
Patterson?
You think
No,
it's
thank you, Your Honor. I
think
have
it's
a
a
rebuttal
joke?
argument if I want to address those.
Okay. All
You
right.
think it's
Thank
a
you.
joke, though?
Closing argument for defendant.
Thank you,
The
Honor. In this
defendant
case,
never
our trial
get
memo
questioned.
basically lays things out. Strickland standards are
Here he
fairly
goes,
specific when
stating
it comes
federal
to
statutes.
dealing with a trial counsel's kind of strategic decisions, and there's great deference given to trial counsel. But the evidence that is presented both in the exhibits today and the defendant's testimony clearly contradicts their claims.
No,
I'd
you
like to start
contradicting.
with,
You
Petitioners
lying,
Exhibit
fool.
13,
I'ma show
page
you.
10, that's Dr. Sweet's report. It's second paragraph down. Says Mr. Johnson has an understanding of how to work and cooperate with counsel, but he does present a dilemma because he has had significant conflicts with previous attorneys.
Show
His
have.
claim is that people do not listen to him and do not
Sure
look at his
don't.
information.
I was
He
telling
knows
the
how to work
truth.
with an attorney, but chooses not to.
I was telling the truth.
Further, the last sentence in the next paragraph down, he said he gives up every right after a plea, including not having a trial and not confronting witnesses to have a plea bargain. When you then go back and look through the rest of his petition or his
He
exhibits,
asked me if I
specifically
understood
Exhibit 8,
how
this is
trial
the affidavit
court
of David
worked.
Coons,
To
they
show
had
if
two
I
office
could
exhibits,
aid and
but then they
assist.
exchanged numerous lengthy emails. He's
So
communicating in emails with his attorneys while he's saying that he would rather have done it in person. Apparently, every single attorney he has communicates in email,
None of them
partly
wanted
because
to
he's
meet
the
me.
one sending them numerous lengthy emails.
He's lying.
Further, this
This
is somebody
dude-
who is clearly demonstrating a difficulty interacting with attorneys of his
I don't
own
trust
volition
him.
based
I
on
don't
Dr.
trust
Sweet's
him.
report. When you read Gail Ryder's emails, you'll see it directly contradicts some of the things he said on the stand, such as she didn't want to meet with him. One of her
She
emails says
didn't.
that she canceled their meeting because he was
I'm gonna show
uncomfortable
you
meeting in
guys. I'm
private.
gonna show you.
Further from that, you have emails where she specifically explains concepts that could be no clearer, but are very easily explained in writing, such as the fact that he has no access to a preliminary hearing when he's been indicted. And yet, even here today, he's talking about bringing suit about preliminary hearing. And as any attorney would know,
Quit trying to cover
it's
that.
easier to do to protect oneself when you are communicating and writing, and you are dealing with
Why are
that
you
in
my
writing,
public defender?
just like the appellate issue where she has, in her emails, in the plea petition, in the court record, told him there's a very limited right to appeal. You have to appeal on colorable issues. Nowhere in there does she say you were going to get and win an appeal on the lack of preliminary hearing or any of the other issues he raised. Instead, she told him you have a very limited ability to appeal. And that's what was signed in the plea petition. As for the remainder of what's been alleged here, this is a defense counsel who very clearly went through all of the evidence.
No, she
if you look
didn't.
at the police reports provided, they're lined out. She's looked at the evidence that's
Okay, let's stop him right here. Let's stop the prosecutor, the defendant that's defending Douglas Hanson. How did they have any evidence if they forgot they prosecuted my wife?
Next matter is Jessica Johnson, 14C43220. Ms. Johnson is present, Your Honor. On her behalf, will acknowledge receipt of a one-count information. We'll waive further reading and advice of rights. Ms. Johnson's true name and date of birth are correctly set forth therein. Your Honor, she would like to take advantage of the EDP offer, which in this matter is that it be treated as a misdemeanor. $100 fine, $20 towards court costs, book and print. She and I have been through the request for attorney and the petition of her plea, which we're prepared to proceed. Thank you.
All right, you're Jessica Johnson.
Yes, you.
You understand what your attorney just said is you want to plead guilty today to one count of prostitution.
Sure.
He has provided me a couple documents indicating your decision. The first is a request for an attorney and acknowledgement of limited investigation. Do you have an opportunity to read and sign this document? Do you have an opportunity to discuss it with your attorney? You understand that with this document, you're requesting appointment of an attorney and have agreed to pay $20 for that service. We're also acknowledging that because you want to take an early offer today, your attorney does not have the opportunity to review the discovery in depth, investigate the charge, or prepare defenses on your behalf. You want to waive that right?
Yes, sir.
And that's how they set me up. There's no information. Y'all dismissed the information in my wife's court. Period, point blank, and I knew that. So let's get
presented
back.
there. She has considered what is available, and she's provided an assessment to the defendant of his chances at trial, which were bleak, to say the least. Further from that, you have emails where she specifically explains concepts that could be no clearer, but are very easily explained in writing, such as the fact that he has no access to a preliminary hearing when he's
That's
been
a
indicted.
lie.
And yet, even here today, he's talking about bringing suit about preliminary hearing. And as any attorney would know, it's easier to do to protect oneself when you are communicating and writing, and you're dealing with that in writing, just like the appellate issue where she has, in her emails, in the plea petition, in the court record, told him there's a very limited right to appeal. You have to appeal on colorable issues. Nowhere in there does she say you were going to get and win an appeal
This
on the
dude
lack
is
of
a
preliminary
buster.
hearing
He
or any of the
deserves
other issues he raised.
to
Instead,
have a new
she
job.
told him you have a very limited ability to appeal. And that's what was signed in the plea petition. As for the remainder of what's been alleged here, this is a defense counsel who very clearly went through all of the evidence.
she
If
did
you look
not.
at the police reports provided, they're lined out. She's looked at the evidence that's presented there. She has considered what is available, and she's provided an assessment to the defendant of his chances at trial, which were bleak, to say the least.
And
This is a defendant who testified today that he wanted to go home and see his kids, and quite frankly, the only way to do that
right.
was to plead
Why?
to a
What about trial?
deal that allowed probation.
What about trial?
And one of the other things I'd
What
like to
happened to
mention
that
very briefly is, so Defendant's Exhibit 101, kind of Sub-Exhibit 11, which is how I received this from Gail Ryder. The second paragraph in that
didn't
email,
receive
Ms.
it from Gail
Ryder
Ryder.
replies, I did get the affidavit from your wife. Oregon law does not allow an attorney to use an affidavit in trial. It's no use to me. In fact, because it contradicts some of your wife's earlier statements to the police,
Then why
it could
would she
actually hurt your
subpoena
case
her?
if I try to use it, because it looks like she's now making up
Why
a
would
new
she
story to help
subpoena
you.
her then?
In the context of this reply is sent. It's clear she's responding to an email. So his claim that he didn't know about the affidavit is clearly incorrect because her response is, it's not helpful, and it's not helpful specifically because it looks like she's making stuff up. And that is an accurate assessment of that response, given that when you look at the police reports where she says, yep, he's here to help me out, he stays in the closet to protect me when things get rough,
It's a lie.
gives him most of the money. And then she later says, well, he had no idea what was going on, even though he actively was caught in the closet when the officers arrived. You
Why
have
would
a
Gail
very
write
clearly
a
fabricated story.
subpoena my
So what
wife?
you don't have is ineffective
Why?
assistance of counsel on Ms. Ryder's part when
Ineffective,
she's
right
assessing
here.
the evidence. You don't have an inability to communicate that to the defendant because she's
Yes.
told him about it.
Yeah,
You
no.
don't have ineffective assistance of counsel when it comes to the appeal because she has told him repeatedly in her emails that some of his appellate claims are not allowable. She has told him on the record that it has to be a colorable claim. She has had him sign a plea petition that says it is a very
She
limited
did
right to
such a
appeal. They
shitty
talk about
job.
it on the record briefly. And in the end, what you're left with is this idea that the defendant's claim that he was somehow unaware of what was going on is just contradicted
I
by
never
the evidence,
said-
which brings me to the final
Never said
assertion
none of
that
that.
his
That's your opinion. fool.
desires were completely overborne by the defense counsel in this particular case because of the deadline. Defense counsel's declaration makes it clear she didn't set the deadline. The state set a deadline on a trial that was ready to go. If you read
He
the rest of
didn't
her
have no
emails, she
evidence,
says
bro.
in one of them, your choice is whether to go to trial or not.
We
You
gonna
have this
see.
choice, but here's the evidence we're facing.
We gonna
This
see.
is what you're looking at if you get a sentence. This is the deal that you have, and you need to decide by this date. All of those are statements of fact. They are not coercion
Yeah,
or any
it
kind
is.
of undue pressure
Yes, it
that
was.
would prevent this defendant
They
from
knew I
making his
wanted
own
to
choice.
go to trial.
As recognized by Dr. Sweet's report, where he has the ability to aid and assist.
Sure
He
did.
has the ability to sit and understand things.
Sure
and
did.
emails are a perfect way to communicate with him because
No.
he has it in writing. He can read it as many times as he needs.
Oh my
In short,
God.
Your Honor, there is no evidence here that there is any ineffective assistance of counsel
This dude is
or
a flake.
that
This dude is a
that
flake.
ineffective
man.
assistance of counsel would lead in any way to a different outcome in this proceeding. Thank you.
All right. Any rebuttal argument?
Just shortly, Your Honor. Yeah, first, in relation to opposing counsel's representation of Petitioners Exhibit 13 on page 10, that's about 3 sentences of a 10-page report that's focused in. It's ignoring all of the other information that's contained with that report that I was speaking about, both in my trial memo and orally here today. And I will just note that when Mr. Callery was going through and saying this was communicated, this was communicated, this was communicated, that was all followed by email, by email, by email. And I think that in the context of Petitioners Exhibit 13, knowing that those problems do exist, whether or not he could communicate with an attorney in person, as Dr. Sweet's referencing, completely irrelevant to communication by email. I'd also like to point out that by saying that trial counsel went through all of the evidence very carefully and was making an assessment that was providing effective assistance of counsel. Unfortunately, what opposing counsel is missing is that when you're looking at post-conviction claims in the context where pleas have been entered, it's not about what trial counsel was doing behind the scenes. It's about what petitioner knew and understood at the time that he entered his pleas. So I don't care if she provided the best assistance anyone's ever seen reviewing police reports and stuff. If that was not communicated to Mr. Johnson, he wasn't able to make a knowing, voluntary, and intelligent decision to enter no contest pleas, and that was not providing effective assistance to counsel, certainly in relation to Dr. Sweet's report, which is Petitioners Exhibit 13. So quite frankly, I think that defense counsel's argument falls flat on its face. We'd ask that you grant post-conviction relief at this time.
All right. Well, Mr. Johnson, post-conviction petitions, as we have done here today, try to establish whether or not a trial counsel gave you reasonable representation and used reasonable professional skill and judgment. And if they did not, did those actions prejudice you in your case? So I look at, in effect, the 3 different claims. And I look at Defendants 101. And certainly Ms. Ryder's position on this is much different than Petitioner's opinion on this. But I do note that as this information has come forward and Mr. Johnson testified today, he again repeated that he has an email that says this, he wanted to plead no contest, and sue the first attorney. And that's come up again. And I don't know, maybe post-conviction is considered suing your attorneys. I don't know about that, but I do believe from reviewing the record that Judge Tripp did clearly say that if you do a no contest plea today, you give up your rights to appeal. And
how did I get this
she made it very clear to him.
How did I get this
And
far?
he wanted, it's very clear today, he agrees, I wanted the benefits of the deal.
No, I did not.
That
They be lying,
I would
bro.
get a downward departure
They
out of
lying.
prison and be placed on probation and
Somebody
be
needs
able
to
to
see
see my wife and children.
That's fucking. Ugh.
So none of that is inappropriate or illegal coercion.
Yes, it is.
And it seems, as I view this, that Ms. Ryder, in an overall situation, it's always, is it reasonable under the circumstances? And as I look at all these circumstances, I do find that Ms. Ryder's declaration
It's a fucking
is
lie.
persuasive to the court.
Because Douglas Hanson
And
wrote it.
Petitioner's testimony, I believe, is refuted by
What?
the record and certainly by Ms.
That's a
Ryder's
lie,
declaration.
That's a lie.
So, as I look at this, I
That's a
see
lie.
that Ms. Ryder, I do believe, based on the evidence,
What evidence?
did perform reasonably.
No
I do
way.
not believe that looking at this evidence that petitioner has met his burden of proof about the elements of the crime and the statements of his wife. In petitioner's memo, there's a statement, although Ms. Johnson's testimony may face some scrutiny in the form of prior inconsistent statements.
So how can you use her?
Well,
Come on, man.
that little clause, I think, is very important
I
because
bet.
given the circumstances of this case, the evidence that was admissible, the fact that Judge Tripp had already had pretrial rulings considering
I thought this
these
was to
issues
see
from
about
different
the
attorneys.
ineffective of Gail Ryder.
I
It's
find
lying,
her
man.
actions to be reasonable.
No. Hell
Um,
no. Fuck
now,
that shit.
I certainly do not find error, and I do not find prejudicial error. The appeal, claims 3 and 4, I think it is clear that Judge Tripp and trial counsel did explain if you take this deal and plead no contest, you lose your appeal rights.
That's a lie.
And as I've said on claim 3, coercion, certainly there's pressure on every
No.
defendant
Not
in
when
a
they
criminal
know they
case.
innocent.
But that isn't coercion, and I see nothing about coercion under these facts. It's just facts that were there that she communicated to Mr. Johnson, and that was available.
No.
So
Fuck that shit.
I will deny the petition for post-conviction relief. Mr. Johnson, I need to make sure that you understand, this is
Man,
my
fuck you.
opinion, based
Yeah,
upon
your
reading
opinion,
this.
punk.
But you have the right to appeal my decision to the Court of Appeals. The important thing for you to know is you have to give notice 30 days from today. And I know that Mr. Patterson would assist you in coordinating with the appellate lawyers if that is what you wish to do, to appeal my ruling. Mr. Patterson, would you be able to do that?
Your Honor, I'll be filing an appeal as soon as the judgment is in the record.
All right. Thank you very much. Is there anything further from petitioner at this point?
No, Your Honor.
Mr. Pat. Okay. Anything else from defendant?
No, thank you, Your Honor.
All right. Thank you all very much. We'll be adjourned.
We're off the record.
They hurry up and turned off the record because they knew I said all y'all prejudiced. Y'all fucking weak as fuck. But anyways, let's get to these emails. These is the original emails from Gail Ryder. The state evidence is this, which is the defendant, right? He said he received this from Gail Ryder. If you made copies from the emails, why aren't they not looking like this? Minus my information. You just copying it off of a server. What happened to the fucking letterhead? They already was altering my emails, right? And some of them. And what I mean by altering the emails is you got to look at what they doing. You gotta read it word for word. I was out of my office, the messages, right? So that's all adding up. Yes, that's all adding up. Right here, Oregon Revised Statute, probable cause, right? And this is me. But remind you, there's emails before this. I went to where the state email started, right? But there's more emails before this because this is an email of Gail Ryder explaining to me, just like Colvin Patterson said, there's so many emails that they chose to hide out. So, seriously. So you go to where it says seriously at. Right there, right? Then you get this part in there. The fruit of the poisonous tree applies to evidence that seized pursuant to the illegal search. And I try to explain that to Gail Ryder. Finally, I have new information from Deputy District Attorney heading your case. Finally, I've received information from the Deputy District Attorney. So we right here. On their side, we reading the DA's information compared to the emails that I got from Gail Ryder. Finally, I've received information from the Deputy District Attorney heading your case. He has sent an offer sheet to me extending offers of probation on each of the two charges pending against you. Should you choose to plead guilty to each charge, the sentence on each will be 36 months of supervised probation with certain terms and conditions. You will have a prison suspended in a range of 35 to 40 months, which would be imposed if your probation was violated and revoked. Right? That you see that right there. I will certainly review proposed conditions of probation with you if you are interested in this offer of resolution. The evidence against you is strong, and if you proceed to trial and are found guilty, you could be sentenced to a departure sentence up to 80 months on each charge. I encourage you to consider this plea offer very seriously. My own attorney, she didn't even want me to put on no evidence. I will see I will see you at our meeting on June 8th. We will discuss the state's evidence against you and potential evidence and plea offers at that time. You see that right there? That's the email. Boom, boom, boom. So when you get to my email, my response back to her, they took it out. They took that email out. They took that email out. The response of me explaining to her, hello, Gail Ryder, according to what you said, that you do not have legal basis to file a motion for change of venue, that you understand that you believe that it wouldn't solve my case for me, but simply have no legal basis to file such a motion. How is that there no motion to change venue when it clearly says this in the Oregon law? I sent this lady the Oregon Revised Statute law, and it said motion for change of venue when made. A motion for change of venue may be made in any criminal action in circuit courts when the case is at issue upon question. I explained to her about this, and you see they just dog me out in it all, right? You can you please explain to me how there's no motion to change venue? Remember, remind you, I am able to aid and assist, so I want a motion filed for change of venue. And like I told her, remind you, I'm able to aid and assist in my own defense. You did make me take a mental health evaluation with Dr. Davis Fleet, and since y'all want to communicate with me through email, well, let's play this little email game. And y'all forced me to have contact with y'all through emails, because remind you, Susan Tripp put me under motion to try to get rid of Gail Ryder, and she said I wasn't even willing to communicate with her. I didn't even want to talk to this lady because I knew she didn't want to help me. At the time of my arrest, I was not in a state of mind due to the fact that I was under a medication of metformin, so I don't know what I really said to the police officers. And another thing is, where is Hernandez's affidavit for the interview? Because I do know that Roger Smith took my money off of me, in which I have a supporting check provided that it's not from illegal activity. I also have a lawyer that can prove that the $1,200 was the leftovers from a $16,000 check. And why are you not entering that evidence? If I told Hernandez that I hold with my wife, then why am I being charged with prostitution and not? Why am I being charged with promoting and not prostitution? Since Hernandez has a verbal statement from me that I prostitute with her, and another concern is I can't be a prostitute and a pimp. So which is it? Did I hold with her? Did I promote her? I can't do both. Since they are trying to use my wife's supposed statements, then why didn't she go to a grand jury and testify that these statements were true? Why is it only these officers testifying on me? Roger Smith, Eric Hernandez, Lance Dede, Brian Benjamin, Scott Amos, Jessica Johnson as a witness, in which she didn't attend the grand jury to testify on her verbal statements, but yet only two of these officers went to a grand jury, Smith and Hernandez. Why didn't the others go verbally told their version of what happened with no substantial evidence to the crime that they are trying to charge me with? See, they left this email out. If my wife didn't attend the grand jury, but yet the district attorney wants to use my wife's statements, well, then let me go to trial and let me face my accuser, because first my wife and I committed the crimes together, which would make us co-defendants, but now she was charged for prostitution and all of a sudden the district attorney has a new evidence. Well, what new evidence does he have, and why don't I have that information? I signed a consent for them to search my car, not my cell phone, but I really like to see the consent card. Never sent me the consent card. She never sent me it. So did you privately pay for the psych eval just for me to take a probation offer? I'm very curious, and why such a different tune from the DA? Why are you sending me his penal codes, and why don't you have legal basis? So if I promoted my wife, you are basing this information off of knowingly with the intent to promote prostitution, receive money from prostitution. So where is the proof of my wife handing me money, and when she clearly stated that she loads them onto various credit cards that are prepaid? So again, how and when do she give me money, and can the DEA prove that other than as a prostitute being compensated for personal render prostitution services pursuant to an agreement that the money was divided from a prostitution activity? Where did my wife and I agree to financial agreements from her rendering prostitution activities? So we got to get to this page right here. And then you see me forwarding to Rapid Lion 667, which is Nicholas Peterson. There's a lot of emails that's missing. I did not pay for the psychological evaluation. Payments for your psychological evaluation was authorized and paid for by the PDSC. Attached is a copy of that letter I wrote requesting payment for an evaluation and the application. Also enclosed is the PDSC authorization for payment for Dr. Sweet's fee. Now listen to this part, which bags up Colvin Patterson's story of her knowing all about the psych evaluation. I have not released Dr. Sweet's report to either the deputy district attorney or the courts. I have only reported that the doctor found you able to assist in aid, because if she released this report to the judge and the judge knew how they was confusing me up and coercing me and using my family against me, there was no way this plea would have went through. No way. Then she gonna try to put it back on me. I will not release the report without your expressed authorization. As to the motion for change of venue, although a statute may authorize the filing of a motion, it can be a waste of time without a legal basis. Filing a motion for change of venue is a waste of time in your case. I'm looking at whether there is significant medical support to file a motion to suppress your statements. I will keep you appraised of my decision. Please, Gail Ryder. See how they took out some of the evidence. They took out all my evidence that I was responding to them, and they just kept their evidence. They kept their evidence. If somebody look at this, Douglas Hanson, is that the reason why you deleted all my emails? Because you think I wasn't going to be able to put this back together? Fool, you is an idiot, bro. You are straight up just a dirty idiot. You think you gonna get away with this shit, bro? It just make me mad every time I think about it, but I know I'm not gonna do nothing to jeopardize or hurt myself or my family and all this. But I am gonna keep on explaining how they said that there was a tremendous amount of emails. You goddamn right there was, and it wasn't me being all happy-go-lucky with Gail Ryder. It was actually me and Gail Ryder going back and forth arguing about the law. Not only that, Douglas Hanson was also included in these emails. And they wanted to clean it up. They wanted to try to clean it up because they knew Douglas Hanson was aware. Look, I did receive a plea offer sent to me regarding Mr. Johnson. Based upon this email to me and his public postings on his two Facebook pages, Matthew M. Johnson Jr. and Cashman Johnson, it is my belief that Mr. Johnson will not accept your plea offer. I want to go to trial. And just like I said, spying don't pay off. Not acting as my attorney, this is an ethical violation. You CC Douglas Hanson into an email that had nothing to do with nothing. You just tell Douglas Hanson, I'm going to trial. The defendant don't want your deal. You CC'd him in here so he can teleport the rest of the way. See, a lot of it is missing. I did some research and I'm very confused on why did the DA charge me within 2 to 3 days. And where is my arrest report? From what I have read, it seems to me that it's the district attorney's discretion on whether he wants to move forward on whether to charge the defendant, in which is me. The prosecutor often runs for office and is nearly aware of the image prosecuting a particular offense sent to the community, and if he doesn't, it is a bad image on him. What witness went to a grand jury since the prosecutor gives the jury a bill of charges and then presents evidence including witnesses in order to obtain an indictment? But in my indictment never was filed because the prosecutor bypassed the grand jury to file charges in a preliminary hearing. It's held with which was waived off record by Kerry Wiley through emails to Doug Hanson. So therefore, the prosecutor didn't demonstrate to the judge that the state had enough evidence to warrant a trial. So why was I stripped of certain procedures? What's the remedy? What is the remedy? I mean, I can read on and on and on, but I'm gonna stop this at 3:30 because I want a change of venue because they are prejudiced and racist down there, and you know it. So I don't think that it's a waste of time to change the venue. Why would you ask me what motions would I like to file, but then when I say what motions I would like you to file, you first lie and say how you don't have the legal basis to file a motion for venue, but then on another email it's a waste of time. What happened to you splitting the charges for disparate conduct? Have you done some research and also talked to a police officer about my wife's citation? The officer told me that a police officer cannot write a police report on a prostitution citation. So I'm a bit confused on you and the DA's outlook of what took place at the time of my arrest. Another thing that that's got me thinking. The fact that I hear Judge Channing J. Bennett tells Michael Lee Griffith you don't have a police report because Kerry Wyland did not waive preliminary hearing. So the real question is, why do I have a police report on what leads the what led the police to arrest me, to arrest my wife, not me? What led the Salem police to arrest me, Matthew Mayfield Johnson Jr.? In an email from you to me, you said you were exploring an additional motion to file separate to separate the two charges since they cover such desperate forms of conduct. So tell me what changed your mind to separate the two charges? I have a good feeling that you and the DA had a private meeting to talk about a plea offer that I never told you to talk to him about. I never told you to talk to DA Hanson about any plea offer. I asked for a jury trial over a year ago, so why would I want to take a plea from the state that I don't state? That don't make sense to me at all. The DA know that I'm not willing to take any offer that he brings up or to the table. It is my right to face those who said I committed this crime. I didn't commit a crime on the state, so tell me why two officers, Roger Smith and Eric Hernandez, go to a grand jury with just hearsay and no evidence of a victim eyewitness to get a real indictment. Again, I hear Judge Channing Bennett set court for May 27, 2014 for preliminary hearing, which I was robbed of by the DA and public defender Kerry Wyland through personal emails off court record. Not only that, Kerry Wyland and the DA never showed up for the court date. I was left in court with no lawyer. Judge Bennett also said something about the indictment if one should be issued on May 29, 2014. After the preliminary hearing, what is your answer for that? I didn't get an indictment until months later because Jessica Kempley's plan was to revoke the preliminary hearing in which I have never waived and make the DA go get an indictment. So tell me what's the remedy for such a long delay and filing for an indictment. The DA and Kerry Wyland was in violation of waiving my rights away, and I am aware of that. Everything they did was wrong to me, and I think you know that. For some reason I still don't understand why my preliminary hearing was taken away from me. If I was in agreement with this, why didn't I take the state's offer? I know why, because I never talked to Kerry Wyland. She was helping the DA. That's a fact, and I have more than enough proof to prove just that. And then I sent them how the grand jury work, how criminal cases get filed, the arrest report. See, they deleted a lot of the emails between me and Gail Ryder, and they say this is Gail Ryder's up under Gail Ryder's declaration. This is up under Gail Ryder's declaration, but Gail Ryder, your declaration is a lie. So are you going to testify to the facts that you didn't write this declaration and that Douglas Hanson did, and he tried to delete all the emails? He got into my computer, tried to delete the emails. Now I'm understanding why he did that, because he cheated my post-conviction relief, because he don't want to be found guilty. He don't want to get caught, but he is caught. The arrest and report. After arrest is made, but before anyone is charged with a crime, the police create an arrest report and forward it to the prosecutor. The report summarized the events leading up to the arrest and the details of the arrest. Dates, time, location, witness, etc. Based on the report, the prosecutor can either file a complaint with the trial court setting forth charges, go to a grand jury, present evidence to them, and ask them what criminal charges, if any, should be brought. And Douglas Hanson did that all his own, elect to not pursue the matter. Prosecutors not only have a lot of discretion regarding whether or not to file, but also regarding which of many possible crimes a person should be charged with, including a later charge. Charges must be filed quickly. Prosecutors generally file criminal charges or not within 3 days, although in some jurisdictions in as few as 2 days, because prosecutors must file so quickly. The crime you are charged with initially may change significantly over time. So he had 2 to 3 days to charge me, and I sat at the Marion County Jail for 22 days with no indictment on me. Rather to prosecute. And I'm telling Gail Ryder everything. I'm telling her everything in here. Grand juries are similar to regular juries, also known as petit juries. Expert that a grand juror's job is simply to decide whether or not charges should be brought in the first place, rather than deciding the guilty or innocent of a person at the trial. A prosecutor presents evidence to a grand jury, and the grand jury turns the verdict or whether or not charges should be brought and what charges those should be brought. Here are some of the primary differences between grand jury and a regular jury. This is me saying all this stuff, sending all this good information to Gail Ryder. And she still, and this Sean Kellery dude, he just was lying for her. Whoever gave him this information didn't give him everything, because I'm believing if Sean Kellery would have seen all the emails and not the missing emails, it'd be a completely different story. And I'm feeling like this is how I was cheated out of my post-conviction relief. They know they cheated me. They know it. I know it. And I'm going to fight to get somebody to see this. To get some, because this is ruining me. The issues you did discuss were explained to you in lengthily by David Kuhn as set out in the emails posted on your website. I'm not going to address those issues. You know why she didn't address these issues? Because she knew I was telling the truth. She knew I was telling the truth. And I'm telling her, Gail, I'm a bit confused. How did you know what Kuhn and I discussed in emails if you didn't have contact with him? And as you already know, Josh James have that one recording. You mentioned you didn't speak with Coons. What website are you referring to? Coons is no longer a part of my case, so what he say is irrelevant. You are representing me now, and being that I have passed your psyche eval and I can aid and assist with my own defense, and that's what I am doing. So what facts are you going off of? It seems to me that you believe Kuhn and I have only had one meeting with you, which was our very first meeting, and you already had your assumptions from Kuhn about me. That's why you had me take the psych evaluation, because you felt I had a mental illness, which you still can't prove that I am mentally ill due to the fact I passed it. Just curious, what have you investigated as far as this case goes? From my understanding, you are supposed to represent me and defend me on the behalf, not what the last representative thought. It seems to me that you do not want to help me out because you are keeping information from the DA and judge about my medical history that your psychological had went over. Why have you not entered none of my medical dealing with my misdiagnosis as part of my defense? My doctor letter is explaining my condition at the time 4 days prior to my arrest, and that professional witness, and that's a professional witness and an MD who is supposed to be subpoenaed to court in my defense, explaining how my condition is due to taking the metformin pill. This is my life that's on the line, and there has been some illegal procedures that have been done. So of course I'm going to fight back hard because this case shouldn't have been prolonged as it has. Another thing, if this case was so strong and concrete, why didn't anyone show up to the preliminary hearing showing and providing the evidence that have no on me to proceed in trial? Why isn't anyone waiting to listen to the transcripts or what was said by judge? If you don't want to properly represent me, then I advise you to file a motion to withdraw immediately, because that our client-attorney relationship has deteriorated to unacceptable levels. I just don't think that the relationship can be repaired to the level necessary. I'm chopping them up in my emails, and they know that. They know it. Mr. Johnson, I know about David Coon's emails because you posted them on your public Facebook website for anyone to read. If you have concerns about my representation, you should address those concerns to Judge Tripp. As I told you in a previous email, an attorney is required to keep the client reasonably informed. That does not include responding to numerous emails. I thought she responded to all my emails, Sean Callery. Each day I have a case preparation to do. That include deadlines, which way is the best way to utilize this information I have about your physical condition before and during arrest. I'm researching whether a motion should be filed regarding that information. Again, you will be supplied with copies of any information. So here go the email. You see how much I had to read before I got to their second email? Go get your clothes on. I'm about to go get your mom. I've been streaming for this long. This one is the longest one, and I don't think I'm gonna get it done. Put your clothes on. I'm gonna do a second part of this. I gotta stop this stream, and we'll pick up on this page right here. Let's see.
So you basically going to do a part 2?
Yeah, I gotta do a part 2 because they took these emails and you.
Constantly your bystanders.
They cheated my PCR, my post-conviction relief. Is Tristan asleep?
Yeah.
Put your pants on. Come here. Go get him a plug. Come here. Go take this off. Go put some. No, I ain't blowing this up until we come home. Go get your clothes on. Again, thank you guys for watching. I'm gonna have to end this, and I'll do a part 2 of this. Again, I have to go over the court audio transcript with you dealing with Coben Patterson. Douglas Hanson cheated my appeal, and I'm gonna show you all the emails. I'm gonna actually just go over Gail Ryder emails. Thank you guys for watching this stream. Please share it.